Hello and welcome to the in-news series of Drishti IAS. My name is Pooja Dwivedi and today we will discuss the split judgment on the Hijab Ban case and what is the case with respect to Bijoe Emmanuel, which is famously known as the National Anthem case as it has been referred by the division bench of two judges who could not arrive at a conclusion with respect to hijab. So, now, as we know the gist of the entire segment, we shall move ahead and talk about this particular news from the perspective of prelims. It's also important that you know about the facts. From the perspective of GS mains paper second, it is important that you know about this particular case because of course you will be asked questions with respect to it. Karnataka Hijab Ban SC delivers split verdict, says there is divergence of opinion. As this was a division bench and it consisted of two judges, Justice Dhulia and Justice Gupta. They were not seeing eye to eye on this particular matter and that is why it caused a split verdict. Moving ahead, let us first of all talk about the bench. What did the bench say? And know about the name of the case. So the name of the case is Aishat Shifa versus State of Karnataka and others. Justice Hemant Gupta, what did he say? It is important for us to know. He said, first of all, he rejected the idea that hijab could be worn in addition to the uniform, saying that if we do allow wearing of hijab in colleges and schools along with the uniform, it might permit one community to wear religious symbols to class. It will be antithesis of secularism. That means it will be just opposite to secularism. If a person is wearing hijab, they might face certain sort of inequality in their appearance, and this is opposite to what secularism is, in which everybody should be seen equal. He also said that for equality and discipline to be maintained, this ban is important and it is the essential hallmark of a secular institution. If we treat everybody equally with respect to a college place being equal for everyone is, not seemingly different in the case of belief system, then of course we will see it as disciplining and equality according to Justice Gupta. What if tomorrow some person belonging to some other, religion believes to practice it in the college? So there will be inequality. Moving ahead, let us talk about what did Justice Dhulia said, Justice Sudhanshu Dhulia. He said, once if you ask any girl, any Muslim girl to take off her hijab before entering the college premises, it is basically invasion of their privacy and dignity, which is of course secured by Article 21 of the Constitution. Whether hijab is going to be used to deny girl students their right to education is another question. How important is religion and discrimination on the basis of religion that a girl who is already grappling with so many drawbacks to get an education, now there is an additional obstacle. Also, we should also practice reasonable accommodation of practice. It will be a sign of mature society. What is principle of reasonable accommodation? Principle of reasonable accommodation provides positive discrimination to a person, in which it is believed that no discrimination should be there on the basis of health, disability or personal belief, and wearing a hijab is a personal belief. This is what Justice Sudhanshu Dhulia said. Now there were some important questions which were raised during the hearing. Some of them are talked about here. Whether the matter has to be referred to a larger bench because there is a pendency of the Shabrimala case already. Whether hijab is an essential religious practice. That means essential religious practice means the practice is to the heart of this particular religion. If one doesn't practice this belief, then the entire religion will change. Then whether it is necessary to establish that hijab is an essential religious practice to seek protection of Article 25, right to worship, right to faith, belief and worship, propagation as well. Whether the right to wear hijab can be claimed as a part of freedom of expression under Article 19, Clause 1, Subclause A, and part of the right to privacy and dignity under Article 21. There were other certain questions such as whether the wearing of headscarf of some other color of the prescribed uniform dress can be allowed on the principle of reasonable accommodation. Do study about this as well. I've already told you. Whether prescription of a uniform in an educational institution can be held to an unreasonable restriction. So these were the certain questions which could not be answered correctly. Now, we have to understand what is a split judgment. A split judgment is when the bench cannot decide one way or the other in a cases, neither by majority or unanimity. So this was a two-judge bench. Now, what will happen next? This case will go to a larger bench, and probably a bench could be of 3 members, so that there can be a majority 2:1, 1:2 like that, or there can be, but the thing is that because it will be an uneven one, split judgment won't be there because it's an odd number, not an even number. Appeal can be preferred before the Supreme Court. In the case of the current situation, the hijab case, it will of course be presented to the Chief Justice of India, who is the master of the roster, and accordingly he will ascertain what has to be done next. Now, what did Justice Dhulia said is important for us to understand from the perspective of examination. With respect to this case, he has said the Karnataka High Court took the wrong path. In the sense, the question wasn't that hijab is an essential religious practice or not. It is ultimately a matter of choice, and Article 19 Clause 1, Subclause 8, 25 Clause 1. Okay, so he said it is a matter of choice. Then he also said that I have held that judgment in Bijoe Emmanuel squarely covers the issue. It straightforward covers the issue. Let's talk about Bijoe Emmanuel case. Now, this is famously known as the National Anthem case. In 1985, Bijoe Emmanuel or Bijoe Emmanuel, Binu and Bindu, they were suspended from the school. Why? Because they did not sing the National Anthem, as these children belong to Jehovah's Witnesses. According to the principles of Jehovah's Witnesses, they are not allowed to sing any prayer. National Anthem is a prayer, and they could only worship Jehovah. This is the premise. They were suspended from NSS school. Beg your pardon for this mistake. 11 other children who were a part of Jehovah's Witnesses, these were also a member of the pupil of this school. So, once they were suspended, the father of Emmanuel, Bijoe Emmanuel, they took this particular case to the court, where he could not get satisfactory answer. They belong to Kerala, and once they could not get a satisfactory answer to their questions, they went on to the Supreme Court. Then in August 1986, Justices O. Chinnappa Reddy and M. Dutt, they delivered the verdict. The name was Bijoe Emmanuel or Bijoe Emmanuel and others versus State of Kerala and others. They granted protection to these 3 children of the Jehovah's Witnesses sect. And they also said that forcing the children to sing the anthem violated their fundamental rights to religion, as they were standing in respect of the national anthem, but they kept silent. Right to silence is also under Article 19, freedom of expression. If you're silent, you're also expressing something. Then Kerala High Court, back then, when this case was brought to Kerala High Court by the father, they said that national anthem, they were actually interpreting if national anthem contained any word or thought which could offend anyone's religion susceptibilities. That means they were thinking if national anthem had any words that were offensive to one's religion. This was the question that they were interpreting. But the Supreme Court said that this wasn't the question at all. It is the right to religion. If their right to religion have something very basic, as such, they do not have to pray to anyone else but only to Jehovah, then why not uphold this? Moving ahead, let us talk about more things that Supreme Court said in that matter. Article 25 is an article of faith in the Constitution, and this is the real test of democracy, in which even an insignificant minority member, religious minority member, or any linguistic minority member are able to practice their religion without any fear. This is the true democracy, to test the ability of true democracy. Our tradition teaches us tolerance, our philosophy preaches tolerance, and Constitution practices tolerance. So, accordingly, Justice Dhulia must be saying that if we allow them to wear hijab in the college premises, it will provide for a more mature society, provide more tolerance. Moving ahead, let us talk about the previous cases which were split in nature. A two-judge bench of the Delhi High Court delivered a split verdict this year only in May. Exceptions provided to marital rape in the IPC. This was discussed. One was for, one was against. Madras High Court Division Bench ordered the in this order when the disqualification of AIADMK MLAs owing allegiance to TTV Dinakaran was also a split judgment in 2018. Now, first of all, there is a question. This is a waste of time. Why not provide division benches of odd numbers and not even numbers so that split judgment cannot take place? Then another point is majoritarian assertion. If any particular judgment that is to come, if hijab ban stays, then it would validate that majority is correct. And they will say it so under the garb of that we are secular in nature. It may lead to denial of opportunity to Muslim women because certain orthodox classes are very orthodox with respect to this norm of wearing hijab. If suppose the ban continues, Muslim women may not be able to receive the proper amount of education, proper quality of education. And principle of reasonable accommodation should, of course, be studied properly before any decision could be arrived at. Okay. Moving ahead, let us talk about the question. You have to answer this. I will take your names in the Monday segment. Which of the following cases is famously known as the National Anthem case? These are your options. You have to answer it correctly. That's it. Thank you so much for watching.